Hi, Connecticut personal injury attorney Ryan McKean here. I'm here with Connecticut medical malpractice attorney Jake Kosienda. Hi, Jake.
Hey, Ryan.
Hey, Jake. Today, one of the things that we talk about is somebody goes in for a procedure. They go in for a surgery or have something done. They take some medicine that they're prescribed by their doctor, and something happens that wasn't intended. They come out of surgery and they've got numbness on the right side of their body, or they have a stroke, or something terrible, and the doctor didn't tell them about that. It didn't tell them about that consequence. Can you talk about that in terms of a Connecticut medical malpractice case?
Absolutely. So that's what we're referring to as a very specific type of malpractice, and that's generally called a lack of informed consent, which essentially means you consented to or didn't consent to a certain procedure without having sufficient knowledge and understanding about the procedure or the medical care that's being given. And that had you been informed of it, you wouldn't have accepted the medical care and maybe chose an alternative treatment method or not had the treatment at all and refused it. The best way to think about a claim like that is it's informed medical decision making, because you have a right to refuse treatment even if a doctor thinks you ought to go through it, but you also have a right to pick an alternative based on the risks, the benefits of the procedures that are being offered in the treatment, and the alternatives that are available. Sometimes you don't have alternatives. Sometimes the risk of not having a procedure and the only one available is far outweighed by the benefits, but not always. The more elective, the more optional the treatment is, the more you have options and the risks and benefits need to be weighed. In emergency situations, you actually don't have that right. The doctors and the hospitals are allowed to treat you in an emergency situation based on their best judgment as what's best for you, because you don't have the capacity to be able to consent. But most procedures, most medications, most recommendations from doctors, you have the ability to make that judgment, and you're entitled to enough information and appropriate information so that you can weigh those risks, benefits, and alternatives and make an informed decision about your medical care. No matter how the doctors or the professionals suggest or insist on care, ultimately really is your decision, not theirs.
And so I think that's it's going to be very important. It's going to be very fact driven because, what papers did you sign before the procedure? What advertising materials, maybe if it's very elective, like a plastic surgery, were you given or provided or not given? What conversations were had, what's in the medical notes and records themselves. Doctors are often commonly, saying, I explained to the patient this, this, and this. So I think it's going to be a very fact driven sort of situation as to whether or not there was informed consent. And in that case, you really need an experienced Connecticut medical malpractice attorney to be able to sort through what the evidence shows, what the law is, and to figure out whether or not there was informed consent and whether or not it was breached. So if you have any questions, you can give Attorney Kosienda a call, 860-471-8333.